Hello and welcome to the big picture. The confrontation and controversy over the land acquisition bill continues. Despite the amended version having been passed by the Lok Sabha, the ordinance which had been brought by the NDA government amending many provisions of the law enacted in 2013 by the UPA government has faced stiff resistance. Some of the clauses, especially one related to social impact assessment, among other things, had been removed in the ordinance. However, the government made some amendments yesterday by bringing in 9 amendments to the ordinance before getting the bill passed in the Lok Sabha. However, in the Rajya Sabha, where it is expected to figure any day soon, the bill may face resistance again. Are the amendments brought in by the government in the Lok Sabha not enough? What are the lacunae in the bill still? And what more needs to be done? This and many other questions still continue to bother the government and the people. To discuss this, I have with me Sompal Shastri, former Minister for Agriculture, Government of India, Usha Ramanathan, independent law researcher and human rights activist, Krishan Choudhary, President Bharatiya Krishak Samaj and a BJP member, S.K.Jindal, Chairman Assocham, Investment and Investors Protection Committee, and Gargi Parsai, Deputy Editor, The Hindu. Welcome to all of you. Mr. Sompal, these 9 amendments which were brought in yesterday by the government, how do you look at those amendments? Do you think that they fulfill some of the demands which have been made by many people so far?
You see, this attempt of amendment also has been confounded beyond recognition now. What do you deem as amendment? Amendment to the original bill passed by the UPA? Or the amendment to the amended bill?
Amendment to the amended ordinance.
Amended ordinance.
Yes.
And or maybe some more amendments, because just now I am coming from the Central Hall of the Parliament. I have been told that it has been referred to the Select Committee. So
it has still not been referred. It has to come before the Lok Sabha.
Okay, maybe it was oral information, so what I gathered was.
It has still not come before the Rajya Sabha.
So I don't know what amendment we are talking of. But you see, there are 3 dimensions of this whole episode. The first is the political propriety / morality. What is the reason that the BJP, who supported the UPA bill and had sought certain amendments which the UPA government had conceded to, and then now they are opposing it. And it was on their insistence that many of the amendments to the original bill were carried out to satisfy them. So where is the ground that they are opposing it now? This is the first question. I was still seeing the file photos of Mr. Rajnath Singh's speech in nowhere else but on the floor of the House.
Right.
Insisting that the social impact assessment is a must, and now they are going back on it. The second aspect is the economic aspect, or the farmers' plight, or the farmers' the treatment meted out to the farmers. You see, the concept of eminent domain, which was invoked by the British when they enacted the bill in 1894, still continues. But during British time, there were very, very, very rare cases where they had invoked the law, used the law for the benefit of the capitalists. They did it for public purpose, except urbanizing the Delhi city, where 35 villages had been shifted and 1 or more. And except cantonments, the British had never acquired lands for the industry. The third issue, and then the compensation issue. For a long time, this was left ambiguous. Similarly, the great ambiguity always was there in matter of the definition of public purpose. What constituted public purpose?
Yes.
So how could housing for the rich people and the industrial lands to be given to the corporate sector who are already stinkingly rich, how could this be deemed as public purpose? This was the objection that we, the farmers' representative, have always been raising. And then the third issue is these exceptions now which are being sought, which had not been included in the first bill, in the rehabilitation and resettlement bill. So I don't know what amendments we are talking, and they have confounded the matter so much that I don't know what.
You don't know what amendments we are talking.
Yes. But one thing, lastly, this has definitely sent a message through the people, particularly the farmers, that this government is anti-farmer and pro-capitalist, and they are furthering the interest of the capitalists in a more unabashed fashion than the UPA.
That you couldn't have made a more forceful statement, Mr. Krishan Choudhary. you are a member of that party which is now part of the heading the government there. How do you look at this? You know, you have heard what Mr. Sompal says. Do you think that the government is adamant in as far as this thing is concerned? After, as Mr. Sompal was rightly pointing out, some of the BJP members, some of the ministers now in the government who were in the opposition earlier made exactly the same demands, and now they are refusing to accede to it.
Basically, I'll talk on the farmers' issue, not on the party issue. Because we raise our issues and we ask that without consent of the farming community, why the land should be acquired. This is our first objection, that consent should be there and social impact assessment should be there, especially the land-affected families. What will happen in the future?
The argument of the government is that, you know, whatever...
Government argument is this, that if a farmer doesn't want the development activities, what type of development? We ask what type of development. Yes, for defense there is no problem, for railway no problem, and for government educational institution, farmer never object. Government hospitals, farmer never object. Always government got the land and there were developmental activities is there everywhere. But now, what type of infrastructure government needs?
No, excuse me. The 9 amendments brought about yesterday.
Yes, I am coming.
In that they have, you know, some of the things which you have talked about, they have managed to.
They have managed the social impact assessment. They have changed the definition, but they have inducted it in amendment. One thing. Second thing, we were asking that there should be employment should be compulsory in all projects
which
for
they have,
every family. They have added
said,
it.
Yes, they have
it has accepted. Third point, because it's a concurrent list subject and it depends on the states also. The exact market price should be decided by the government.
Another thing the agriculture minister said yesterday while replying is that, you know,
the multi-crop.
As far as social impact assessment is concerned, he said individual states are free to go ahead and have that clause in there.
Yes, for every state is free to make their own assessment. And multi-crop land will not be the priority to acquire anywhere in the country.
Will not be the priority, but it will be acquired if it is necessary. If they think it is necessary. Whereas the original act said that no multi-crop land.
Up to 10% in original act was there in 2013. It was up to 10%.
Right. Okay. Usha, how do you look at this, you know?
Yeah.
Are you still not convinced about, you know, about the bill even after these amendments?
See, if I can just say in brief what my problem has been through this phase. The first thing is that there was no logic to bringing in an ordinance. You know, that itself has devalued any credibility that the government might have had. And the reason I say this is because they kept using those 13 laws as the excuse.
Exactly.
Whereas those 13 laws to bring that in only required a notification. It did not require an ordinance. So that was it was a way in which they misled many of us. If we hadn't looked carefully, we would have thought, oh, maybe there was an ordinance needed. It was not required. They needed to do it by notification. It's plain by now that the reason that they did it was used as an excuse to bring in all these other changes that they wanted. The second thing is, I think I'll talk about a few of the things that many others are not talking about in the hope that this will in fact go to a committee and that the committee will consider some of these things. One of the most disturbing parts of this law, which actually negates anything that the 2013 Act did and anything else since, is this introduction of Section 197 of the Criminal Procedure Code into this law. See, we've had laws over the years. When the colonial administration passed those laws, they said that everything will be presumed to be done in good faith, and you have to demonstrate that it was not in good faith if you have to bring them within any kind of answerability. What they've done here has gone way beyond that. The 2013 law said we'll punish anybody, any official who does not perform their function under this law because it destroys people's lives if you do not keep a promise under this law. Right. Now what have they done? They've said we are bringing it in where nobody can be prosecuted, no action can be taken unless the government is going to give sanction for prosecution. So what does that mean?
That seems to have been
still there.
That seems to have.
Why should the government give sanction when they are doing under instructions and orders of the government?
This is self-defeating. One of the amendments brought in yesterday is that the court shall take cognizance of offence provided in the procedure.
The special provision have been done.
Yes.
But it's the same thing.
There is appeal provision there.
Is not there.
And one more thing, that no land will be acquired for any private company directly.
Girish ji, that exemption that the cognizance by the court has been limited to the level of deputy secretary. Joint secretaries and above, who are the real people who order these things?
Okay, we are now joined in by Gargi Parsai. Gargi Parsai is the deputy editor in the Hindu. Gargi, what can you bring some clarity to these amendments which have been brought about yesterday, especially this particular section which we are talking about?
Well, you know, the amended before the bill was amended, it said that for any aggrieved farmer or any person whose land has been taken, he cannot approach even the police, you know, to lodge an FIR unless a permission is taken from the head of the department of that official who has failed in his duty, whether it was in rehabilitation or paying compensation, which we are seeing in the Narmada Dam ousties, you know. There has been a whole lot of scandals in Madhya Pradesh where people have not, there have been fictitious registries and all kinds of things have come up. So now the government has said that the courts can take cognizance after the person has fulfilled the other processes, which means the government should have given a permission to the person to go to a police and a case should have been filed against that official. Only after that will they take cognizance. Earlier the law said that the court will not take cognizance at all. So that is a slight change that they have brought in, but I don't know how useful would that be.
Usha?
Yeah, the thing is, the basic idea is to retain control over prosecution.
Exactly.
And that they are doing. So you can be affected. It will negate the meaning of this law if
Mr. Nikam, this has to be put straight, this record. Any official does not acquire land on his own whim and fancy.
Absolutely.
It is under the policy and explicit instructions of the government, the political power.
Right.
And how would that government grant a permission to prosecute the officer who has been obeying the government order? So this is totally self-defeating thing, and it's totally misleading and deliberately misleading.
Okay, Mr. Jindal. Mr. Jindal, how do you look at it? You know, you think that these demands being made, social impact assessment for one, and second thing is the consent of the farmers, which had to be required in the earlier law. Now it's saying, so you think that these two clauses are, you know, if they are brought in as being demanded, will it lead to the industry? Will it lead to business houses not being able to do business, not being able to acquire land, not being able to set up industries?
First of all, you see, I would like to welcome this step of the government. They have done it very well and they are doing their best. This is if this supports the growth of 125 crore people, then why not? And if it doesn't support the growth of these 125 crore people, then it should not happen. But I personally feel that government is accountable and responsible for the growth of these 125 crore people. And these 9 amendments have been done to balance the rights of farmers with the urgent need for future projects for the growth of the country and its people. So I personally feel that it's a welcome step and it should be welcomed by all. Whatever other amendments, if any, is required, by discussion, by talking, we can work that out. But we should not stop it from happening. If we stop this thing from happening, then we cannot think of any growth for these 125 crore people.
Mr. Jindal,
when people claim or blame that this is only for the... Yes.
Mr. Jindal, my question is this. Social impact assessment, one of the major demands being made by everybody is that how can you not have social impact assessment before acquiring land? You think that this social impact assessment will come in the way of industrialization, of the development which you are talking about?
Social impact is also very important. We cannot ignore that, but at the same time, there has to be a balancing act to be done, and both things should proceed side by side. Growth is also important, and social impact is also important.
Okay. Yes, no, but Usha, yesterday's thing also says that there will be hearings as far as land acquisition and rehabilitation should hold hearings in districts where acquisitions take place. This is almost, as social. Isn't this something akin to social impact assessment?
I just want to make a brief, small comment on Mr. Jindal's statement. I really find it interesting that in the past 3-4 months especially, and even a little before that, we have dropped the word development from this whole discourse. It has just become growth now. There is not even a pretense that this is growth and development. And I think that's fair. I mean, I'm glad that it is coming out as openly and honestly as it's coming out. Because
this is what the government is also saying. It's not just...
It's just growth.
This is what the government is also saying, that if we insist on all these things, then there will be no growth. No
growth. It's only... No, I'm sorry. They're not saying no development. They're talking growth. Growth is a very different thing from equitable development. They are two different things. And I must say that I was a member of a committee last year. The government has not released our report yet, although it is there available in the public domain on tribal communities. And we know that the reason that the 2013 Act came in was because of the number of conflict points when it came to handing over land, because people had seen that over the years, they had found themselves being promised many things, sometimes not even being promised, and being left high and dry. The discourse had changed a long time ago into including mass displacement. And that cannot be done unless there is an earnestness. See, it's a question of who the law is working for. Like you said, Mr. Shastri, I agree. If the government is going to say openly that, listen, here we are to try and simplify everything through the coercive force of law to make industry able to get everything, it's treating the industry as some kind of weak party.
And as if industry is only 125 crores. The farmers who are 82 crores in India, they are not included in 125 crores. Their interest can be overlooked by anybody at their whim and fancy for the benefit of the capitalist, and it constitutes development of 125
Mr. Choudhary, no, you are also a member of the party, so you are an influential member of the party. Why is it that you people have not been able to influence the government because what you are saying is actually what others are also talking about? Where do you think the problem lies as far as the thinking in the government is concerned?
There are two things. One is the development agenda. Second is how to create the employment.
Agenda?
It's a corporate agenda. But as per the farmer side, there is a where and how the employment. There is a question of employment coming. 40% young generation is not satisfied in agriculture sector. Everybody knows. Everybody raised this issue. You also raised this issue. But where is the employment? This is our question. They are asking, young generation asking for employment. Country is asking GDP or growth, but young generation in the rural area. Farmers also needs development, share in the development. They are also a requirement of the power generation, for irrigation, for road development, for
infrastructure.
Infrastructure is a second thing, but infrastructure for the post-harvest technology, for storage side. Different type of infrastructure there is a requirement in the rural area, and why the farmer should not be the shareholder in the development in the present scheme, and why not employment should be given to the unemployed youth.
Please tell me, these 9 amendments which have been brought in, you think that's enough?
We raise all things, minus one thing is there, that there is no need of consent directly from the farmers. This was our main demand, and
there should be consent.
It should be.
Yes,
it should be.
Okay, Gargi,
and there should be no land acquired for private sector. We asked with the government, and government accept that no land will be acquired for private sector.
His question, Kashmir ji, whether you have been able to influence the government.
That question he can't answer. I think we should make it.
How I can answer this?
Because you are an influential member of it.
We raise our demand. We raise our demand, and they accept few out of that.
Gargi, what next now? What is the government's thinking now? Now that they have been able to get it passed in Lok Sabha for obvious reasons, they have the numbers there. Though it's a fact that some of their allies had walked out or didn't support the bill. What will happen in Rajya Sabha? What do you think the government is planning?
Well, the government, I think, plans to have another round of talks with the leaders of opposition parties to bring them on board. I think, and they also have not been able to, for whatever reason, convince their own ally, the Shiv Sena. Shiv Sena abstained yesterday from voting.
Right.
And they have had some success with other allies who have come on board by saying that you can have, like for instance, Shiromani Akali Dal, which was opposing the bill, has been persuaded by saying that you can have your own version of the bill in the state.
In the state.
Since the land is the state. No. So several states, several parties, let me say, who are ruling in states have been convinced by this logic. Even though the bill does not have two major things, which people were saying yesterday was the atma of the bill or the soul of the bill, that is taking consent of farmers for acquisition of land for private purposes and for PPP. But let me also bring on the table another aspect, that when land is acquired for even government works, public works or for public entities, there is, so the devil lies in the details, as they say, that public entities include the educational institutions and the private hospitals, private educational institutions. Now, when government acquires land from farmers, saying it's for a public purpose, then no consent is taken. And we have seen in states like UP and even in Haryana that the land use is changed. And when the land use is changed and the land goes from government to the private entities, then no consent is there.
But Gargi, the question is that yesterday one of the amendments which was made was that the acquisition of land for private hospitals, education institutions no longer counted as public purpose.
Yes,
so they have addressed that.
They have included infrastructure, and the definition of infrastructure
social infrastructure.
Whatever, social or general. The definition of infrastructure is defined in a notification issued by the Department of Economic Affairs, where all these entities are listed. So that's why I'm saying the devil lies in the details.
Yes,
but now the private hospitals and private institutions have been excluded again in the present amendment yesterday.
So to that extent,
this is not because of the generosity of the government. This is because of the compulsion of the parliamentary numbers.
There is no doubt about it.
And this is a confession to their
Mr. Shastri, I have another question for you. You have been a minister in the government, you have been an MP, you understand this. Now, this is a concurrent list. Now, the government is saying, the agriculture minister yesterday said, okay, states can have their own. How practical is this for states to have a separate, as far as these issues are concerned, can states put in clauses saying that, consent has to be taken, social impact is assessment, how practical are it?
Very, very important aspect, and this raises a question about the theory of jurisprudence and the legislation, because if something lies in the domain of concurrent list, it is clearly laid down that if there is a federal or central law existing, the states have to abide by it. And if there is none, then states can enact there. But if there is a law laying down certain thing in letter and spirit, there is no reason that government of a state can do something else than what is provided for in the basic law. But there is one clause invoking which the Haryana government has already done the damage. You see, the formula of compensation, which is the crux of the whole thing, was the market rate as defined by the circle rate, which is notified by the administration every 3 or 6 months, depending on the registries that have taken place and the values that have been aggregated and averaged. Equal to that market value would be the compensation. And whatever amounts now aggregates as compensation plus equal to compensation, equal to that amount would be the amount of solatium. But in Haryana, they have subverted the formula itself. They say 1:1 rather than 1:2. And if states are given this, the states are no less if it comes to working against the farmers and working for the vested interest.
Usha, how do you look at this? This is a legal issue.
It's a legal issue. See, the thing is, this seems a compromise situation for them to say that, well, if you, in the parts that you think we are bad.
Gargi is saying that some of the states are now, are coming around and thinking, guys, why we are going to have this freedom to do what we want. So let us accept.
It's not actually making freedom, but the central law will be the guiding principle, and then
naturally.
But Gargi, on the compensation ground.
You see, first let this be sorted out. This legal question. Please.
See, the thing is that when the centre is making a law, the basic principles have to be established in that law. If you're already making the law saying you may deviate from the basic principles, what is the point? What is the exercise that's being done here? What does it mean?
Exactly.
Second thing is, I think we also need to see this law in the context of other changes that are coming in laws. When we talk about this employment being given, have you seen what is being done with employment? The way labor is being villainized by this present government. It's been happening over some period of time, but this has completely done it. Where now you want a hire and fire policy, even to the extent where you're saying you electronically notify if you're going to shut down a plant, if you're of a certain size.
No, but that's it.
In this context, to depend on this as the employment that is going to be the resurrective force for people who are going to be displaced, it seems not just unreal, but we have to really blindfold ourselves completely to be able to see this as a serious rehabilitative.
Girish, but one aspect that we are missing completely in the social impact assessment concept is the plight of the people who are affected who are not landowners. You see, landowners would
they have brought in the clause of agricultural laborers.
But in this discussion, we are talking of farmers. At least they are getting some compensation.
No, agricultural
but
laborers
what about the people who were dependent on that
That is what the social impact assessment is supposed to do.
Therefore, social impact analysis is not to be left to the freedom or choice of the states. It has to be compulsory. That was the original idea.
Absolutely. Mr. Jindal? Yes. Mr. Jindal, there are two questions as far as there are only two major controversies regarding this, which the government doesn't seem to be agreeing to. One is the social impact assessment, second is the consent of the farmers. Now, you think that even if, let us assume that under this present law, the industry, the corporates, whoever is going to enter into businesses of various kinds, acquire lands, do you think that there will be a atmosphere which will prevail in that region where you can do peaceful business? So don't you think that this is a very important thing?
That's the issue.
This is very important, but let me tell you that these farmers who are 70% now, they will not remain farmers all their life. They also want to change, and growth and development can only provide them jobs and opportunities. The 9 amendments which have been made, I think they are enough for the time being, and one should start working on them. And in future also, you can always make amendments whenever required.
Okay. Gargi, do you think that the government is in a mood to further climb down, further bring about more amendments? Do you see that kind of an atmosphere in the government, among the people in the government?
Positive attitude is very important.
Gargi?
No, I don't think the government is in a mood to climb down any further than what it has. And it remains to be seen whether it wants to go for a joint session or wants to come up with another ordinance.
Mr. Shastri? Joint session seems to be there.
There is the question of mood. They had overtly declared their mood. And now this come down is because of the compulsion of parliamentary numbers. So and this is because of the force exerted, the democratic force exerted.
There is a compulsion of democratic numbers. So that's about.
So I don't think discussing the mood is of relevance in this case.
Okay.
Yes.
Usha, very quickly.
I just want to say this, that when we are thinking of
amendments in future, not just now.
Right.
When we are thinking of acquiring something, bringing in a law to acquire, we are not talking about people, we are not saying farmers want to move on and therefore we are helping them by bringing in a coercive law. I think we should leave that argument aside. And I really think, since many of these changes are fundamental, and the earlier law, for all its fault, went through a very democratic process, whatever might have come at the end of it. There is an importance for that process and they should accept that.
Okay. Krishan, you think your government will accept it?
That's the job of parliament.
Amendment can be done anytime. It's not a day that today it's all closed.
So are you saying that, let us accept what has been amended now and then see the future?
If the farmer will not satisfy the way of working for acquiring the land, then the problem will occur in the country. So, and again, the changes will be there.
If I go by the perception of Mr. Jindal that farmers want to go out, that means they would happily give their...
point, sir.
They will assign their consent, then where is the question?
No, the question is, should we accept, now that the 9 amendments have been brought in, should we accept, let us start working on it, and whatever amendments needs to be made later as we work the law.
Laws are not made like this. We know that parliamentary time is important. You don't just make a law and say...
Okay. I think
and
on
why
that note...
should one go for amendments later? Why not accept the 213 Act as she's saying?
Okay, I think on that note we need to end, but we'll wait and watch...
213 Act.
But we'll wait and watch how the government will respond to this and how it will tackle the issue when the bill comes before the Rajya Sabha. Thanks to all my guests. Please keep watching. We'll come back with another issue in the big picture same time tomorrow.